The courthouse buzzed with its usual mix of urgency and routine, but inside courtroom 4B, a battle was quietly unfolding, one that would reveal how diligence and knowledge could overturn attempts to undermine justice. Andre Williams, a 33-year-old black man, sat composed at the defense table, his fingers lightly tapping a thick legal binder filled with documents, case law, and procedural notes. His calm demeanor masked the intense preparation behind every move he was about to make. The prosecutor, Rachel Myers, was known for her sharp tactics and aggressive approach. Today, she filed a motion to fast-track Andre's trial, pushing for an expedited hearing on charges that carried heavy consequences. Her rationale was efficiency, saving court resources and serving the public interest. But Andre and his defense team knew better. Fast-tracking a trial often meant less time to prepare a defense, fewer opportunities to gather evidence, and increased chances of procedural errors, especially when defendants were minorities or faced complex charges. As the judge called the session to order, Myers stood and argued for the motion, emphasizing the need for swift justice. She highlighted the backlog of cases and the victim's right to closure. Andre listened carefully, then rose to address the court. Though not a lawyer, he had taken it upon himself to learn the intricacies of his case and courtroom procedures. He filed a motion the previous evening, a detailed and meticulously researched objection to the fast-tracking proposal. Your Honor, Andre began, voice steady and clear, I move to oppose the prosecution's motion to fast-track this trial on the grounds that it violates my constitutional right to a fair trial under the Sixth Amendment. He proceeded to cite precedent after precedent, Barker v. Wingo, which established the right to a speedy trial balanced against the right to adequate preparation. Strickland v. Washington, underscoring effective assistance of counsel, and several district court rulings about procedural fairness. Andre explained how the rushed timeline would unfairly prejudice his defense, noting that his legal counsel needed adequate time for discovery, witness interviews, and expert consultations. He also highlighted recent amendments to local procedural rules, which mandated certain minimum preparation periods in complex cases, periods the prosecutor's motion would ignore. The judge, a seasoned jurist known for her careful weighing of arguments, listened intently. The courtroom, filled with reporters and spectators, fell silent. Myers attempted to counter, suggesting the defense was simply delaying tactics. Andre remained composed. This is not about delay, but about justice, he replied. Expedited procedures cannot come at the expense of fundamental rights. After reviewing the submitted motion and hearing both arguments, the judge ruled in Andre's favor. The court finds the defendant's concerns well-founded. The motion to fast-track the trial is denied, she announced. The courtroom erupted in whispers of approval and surprise. Andre's strategic filing had effectively halted the prosecution's attempt to rush the case. In the following weeks, Andre and his legal team meticulously prepared their defense, uncovering new evidence and building a strong case. Ultimately, the charges against Andre were dropped, the prosecution unable to meet the burden of proof with such a well-prepared defense standing firm. Andre's stand became a landmark example of the power of knowledge, persistence, and the rights guaranteed by the Constitution. In a statement after the trial, Andre said, "Justice isn't about speed. It's about fairness, truth, and the chance to be heard fully and fairly. When the system rushes, it risks mistakes, and those mistakes cost lives." His courage inspired others facing similar legal challenges to educate themselves and stand up for their rights.